just announced that they'll be launching an online rescheduling of biometrics appointment. And that could be if you're on an F1, H4, filing a B2 extension, or of course, if you're filing a green card, there are many instances where you might need to go for biometrics, which is basically you go to an office and they take your photograph and fingerprints, and then they do a security check. So that's the biometrics. So as of June 28th, USCIS launched a new self-service tool allowing people to and their attorneys to reschedule biometric services online by going to your portal or creating a portal for yourself. So that's, USCIS has been trying to automate, has been doing things online a lot. There's some forms that can be submitted online. There's still a lot for them to do. They haven't even touched the tip of the iceberg, but it's a start. So they're starting to offer some services online. Next, quite important, but not as important as it could be, is that USCIS has provided further guidance on, as of June 14th, on employment authorization documents based on compelling circumstances. So USCIS allows employment authorization for a person who has an I-140 approved and whose visa number is not yet available. So they've had this before, but now I guess not many people are using it because it's not clear as to who is eligible and who isn't. So recently they have given some explanation as to under what compelling circumstances or under what circumstances a person can actually file an EAD. So for an applicant to be eligible for an initial EAD based on compelling circumstances, first of all, they must have an approved I-140, either the first, second, or third employment-based category. The principal applicant has to be on an E3, a H1, H1B, O1, L1 non-immigrant status when they file the EAD, or they could be in the authorized grace period. For example, the 60 days grace period, sometimes if a H1B loses a job, they have 60 days grace period to find another job. So that's the 60 days grace period. So you can be in that period also when you're filing for your EAD under compelling circumstances. Also, the applicant should not have filed a 485. Immigrant visa number should not yet be available for the applicant. They have to provide biometrics. They have to have not been convicted of a felony or a misdemeanor. And then, of course, most importantly, USCIS will then determine as a matter of discretion whether the applicant demonstrates compelling circumstances or not. So the guidance with reference to what covers compelling circumstances, it's a non-existent list of situations. So it doesn't have to be list 1, 2, 3, but they've given some suggestions as to what could possibly be compelling circumstances. So serious illness. So this is basically, obviously for people who have lost their job, because if you already have a job, you would be on a H1. So this is when you cannot be on a H1 or L1 or one of those other situations because of some compelling reason. Then you can apply for this EAD, and you can work for any employer then. So this compelling circumstances includes a serious illness, a disability, maybe an employer dispute or retaliation by the employer because of which you've lost your H1. Other substantial harm to the applicant, significant disruption to the employer could be a reason. The guidance also provides details on evidence that the applicant can submit. For example, if the principal applicant is saying that the compelling circumstances, the fact that they've lived here for many, many years, they could submit evidence that they went to school here, maybe went to high school here, so all the enrollment records. If they're saying that they have some financial difficulty, meaning that they can't pay their mortgage, then you could submit mortgage documents, etc., etc. So if, say, they'll have to pull their kids out of school because they can't afford the tuition, you can submit evidence of that. So this is all the evidence that you can submit for cases under compelling circumstances. This is great, especially for non-migrant workers who've been laid off. This will benefit them because then they can, if they're able to get an EAD, then they can work for any employer. But it's still very narrow in scope, mainly because first thing is that we don't know which cases that the USCIS will approve and which cases they won't. It's really seems to be quite subjective. It depends on the officer. Also, it takes a long period of time, so there's no premium processing for this kind of EAD, so it could take several months. So you might be left without a job, without work for several months because you can't work on a pending EAD. Also, this type of EAD doesn't confer an actual non-immigrant status on the applicant. It only allows you to live and work here. It's intended as a stopgap, and it's allows you to, it's considered to be a period of authorized stay, not an actual non-immigrant status. So you won't accrue unlawful presence, so that's a good thing. But you're not provided with any path to green card. You can't file a green card while you're in the country. So you can't file adjustment of status. You can't file a change of status to a H1. So you'd have to leave the country, get a H1, get a visa, and come back in if you want to get back onto H1. And also, it's each time you have to extend your EAD. This might take again several months, and you might find yourself without being able to work because your EAD is still pending. So they're definitely, I mean, it's good for a person who's desperate and has no other means to stay in the country and work, but it's not ideal. It's not an ideal status to be in for those many reasons that I just mentioned. Going to the next topic, USCIS expands premium processing as of June 12th. They expanded premium processing for applicants seeking a change of status to an F, M, or J non-immigrant status. This is great for people who are filing for a change of status to an F1 status, to a student status. Previously, it was an issue of being able to file a change of status because change of statuses were taking 10 months or more. And, it's difficult to stay in status for that long. I mean, it's difficult because your school will start at some point and you won't be able to join school. So to time that, the start of classes versus USCIS approval of the case was very difficult. So even if you got an approval, it would be useless because of the time taken. So that's very important that they started premium processing for these kind of cases. So you can actually, with more certainty, enroll in a school and, start classes on time. Another interesting development as of June 29th, very recent, is for H-1B holders. It's not US immigration, but it applies to people who are on a H-1, so that's why I thought I'll mention it. Canada announces a new program for H-1B, for holders of a H-1B visa. They're giving them pretty much an open work authorization. So if you have a valid H-1B visa, you could go to Canada and apply for the Canadian work permit, and you could work for any employer. So please remember this. This is being done by Canada, obviously, to attract high-skilled workers who are in the US. They also give work authorization to dependents. So this could be attractive for some people that maybe prefer to work in Canada if there are opportunities because they can work for any employer. And the dependents can work as well, and there are not that many restrictions. So, it's a great way for Canada to, get, the high-skilled workers from the US. The only thing is that it says that they have to have a H-1B visa. It doesn't say H-1B status. So I'm presuming it's not enough if you have a H-1B I-94, but you have to actually have a visa. So if you don't have a visa stamped in your passport, you may not be eligible for this work authorization.